Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And today I'm challenging myself. I'm reaching into the Legal Hotline mailbag, and we're calling this a rapid fire hotline mailbag video because I'm going to try and give you 3 questions and answers in a time frame that doesn't leave you bored. Okay, so here's where we go. First question. Listing broker is listing property for a seller who's had a bad experience with a local real estate broker and has advised the listing broker that under no circumstances may the identified real estate broker enter seller's home. How, as a listing broker, do I handle this scenario? Simple answer. Listing broker, you got to contact your MLS. This is not a matter of state law. State law does say that seller, as an owner of real property, one of the sticks in the bundle of rights that the seller holds in owning title to property is the right to exclude anybody from seller's property that seller doesn't want on their property. Now, the Fair Housing Act will limit whether or not a seller can exclude buyers based on a buyer's membership in a protected class, but we're not talking about that in this question. This seller's had a bad experience with a real estate broker and doesn't want that real estate broker on their property. So state law says, seller, you can do this. But the answer to the question is not controlled by state law. The answer to this question is controlled by MLS rules. Listing broker, you need to contact your MLS and find out if and how seller can actually exclude an identified real estate broker from the property. And when the MLS gives you your answer, that is the only answer you can give the seller. And if the answer is not satisfactory to the seller, then the seller can choose not to market their property through the MLS. Question number 2. Buyer failed to close by the closing date in the contract. Buyer's lender did not send a letter required by Form 22A, paragraph 5. Therefore, I'm concluding that the buyer is not entitled to earnest money based on the financing contingency. Here's the answer to that question. Listing brokers, the financing contingency survives termination of the transaction. There's language in the Form 22A financing contingency that specifically says the financing contingency survives termination of the agreement. What does that survival language mean? It means that even though we go past the closing date and buyer has not yet provided proof that they're entitled to recover their earnest money, their financing contingency continues to protect them. And buyer can still, even after the closing date, provide a Form 22A, paragraph 5 letter from buyer's lender to seller proving buyer's good faith effort to obtain the loan identified in the Form 22A. And if buyer does that, even a week, a month, a year after closing, buyer will still be entitled to the earnest money so long as the financing contingency was actually active on the date that the transaction failed to close. In other words, the closing date where closing wasn't achieved. Side note, this is why sellers and listing brokers, it's really important that you exercise sellers' rights under paragraphs 2 and 3 of the Form 22A, but we've covered that in another question in another video. Question number 3. Question number 3 deals with a condominium purchase and sale agreement, Form 28. Here's the question. Paragraph 17 of Form 28 has a blank to include, quote, deposit equal to blank month's assessment at closing. Question is, what does that provision relate to? Seller is afraid to put a number in there because seller believes it's going to obligate seller to pay additional funds at closing. Paragraph AA, so it's the very end of the boilerplate language in Form 28. It's small a, paragraph AA of Form 28 explains this provision. There are 2 blanks in that question, the specific terms provision. The first blank requires seller to identify what the HOA dues, just the regular assessment is. And then the second blank relates to a deposit that may be charged by the association to an incoming buyer. It's entirely possible that the HOA charges no deposit to the buyer, and in that case, that number would be 0. But sellers, in order to answer this question, you need to contact your HOA, find out whether or not the HOA requires the buyer to pay a deposit, and if they do, fill the deposit amount into that blank. It's never the seller's obligation to pay the amount in that blank. It would be the buyer's obligation to pay that deposit to the HOA at the time of closing. If you have questions on these topics or any others, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.